Hello everyone. We will discuss about topic company law today. Number 1. The Companies Act 2016, CA 2016, repealed the Companies Act 1965, CA 1965, and changed the landscape of company law in Malaysia. Number 2. The CA 2016 reformed almost all aspects of company law in Malaysia, where the law added more sections to accommodate the lacking elements. Section 9 of the Company Act 2016 defines the essential requirements of the company as having: Number 1. A name. Number 2. One or more members having limited or unlimited liability. Number 3. A company limited by shares has one or more shares or directors. Companies Commission of Malaysia, SSM. A statutory body formed as a result of a merger between the Registrar of Companies, ROC, and the Registrar of Businesses, ROB, in Malaysia, which regulates companies and businesses. SSM came into operation on April 16, 2002. The main activity of SSM is to serve as an agency to incorporate companies and register businesses, as well as to provide company and business information to the public. Classification of company can be divided into two. First, limited by shares. Second, limited by guarantee. Limited by shares. Number 1. A company limited by shares is a corporate entity that is legally separate from any directors and shareholders. Number 2. In Section 10(2), a company is limited by shares if the liability of its members is limited to the amount, if any, unpaid on shares held by the members. Number 3. Shareholders receive a share of business profits. Number 1. You can choose to sell shares in your company at any time in order to raise additional capital or grow the business. Number 2. Ownership of a limited company can be passed on. Number 3. Companies limited by shares, allowed for strategic financial planning with regard to tax. Limited by guarantee. Number 1. There are no shares or shareholders. Number 2. To become a guarantor, you must guarantee a fixed sum of money to the company. Number of members. Unlimited of members for public company, and maximum 50 members only for private company. Number of directors. Minimum 2 director for public company, and minimum 1 director only for private company. Annual general meeting. Compulsory for public company, and not compulsory for private company. Invitation to public to subscribe to the share. Allow any invitation to the public to subscribe for any share for public company, and prohibits any invitation to public to subscribe for any share for private company. Incorporated association. Number 1. Every company must be compulsorily registered or incorporated under the Companies Act 2013. Number 2. According to Section 3, the minimum number of persons required for forming a private company is 2. 7 for a public company, and 1 for one-person company. These persons are also known as subscribers to the memorandum. Separate legal entity. Number 1. A company is in law regarded as an entity separate from its member. It has an independent corporate existence. Number 2. Any of its members can enter into a contract with it in the same manner as any other individual can, and he cannot be held liable for the acts of the company even if he holds virtually the entire share capital. Limited liability. Number 1. In a company limited by shares, the liability of members is limited to the unpaid value of the shares. Number 2. Company limited by guarantee is an incorporated firm without share capital, and in which the liability of its members is limited to the amount each one of them undertakes to contribute at the time the firm is wound up. Common seal. Number 1. Common seal is the official signature of the company. Number 2. Any document on which a common seal is affixed is deemed to be signed by the company. And that wraps up on our topic today. Hope you all have a good knowledge on company law now. Thank you for listening. Bye.